Hello, everyone. Welcome. Good afternoon to another live edition of Employment Law Q&A. I am employment lawyer Alex Lucifero. I'm managing partner of Samfiru Tumarkin's Ottawa office. Samfiru Tumarkin has offices across Canada in Ottawa, Toronto, Calgary, and Vancouver. This is, as I mentioned, a live Q&A with an employment lawyer, with myself. I'm here to answer any and all questions really related to employment law, related to the workplace. If you are watching this and you're dealing with a situation at work, you're struggling with your boss, you're not sure if your employer is treating you properly, maybe you've been let go from your job for one reason or another, and you're wondering whether your employer has done the right thing or not, this is your opportunity to speak with an employment lawyer, get your question answered. Certainly, I will be answering any and all questions in the chat, as is my custom. I am a no-holds-bar, will answer anything under the employment law sun when it comes to these live Q&As. So you are in the right place. If you have an employment law issue, if you're struggling with something at work and you've come across our channel, by all means, go ahead and ask your question. Let's get your particular workplace problem resolved. Now, before I go into the questions, and as you're listening, guys, feel free to start typing up your questions. Let me know what topics you want to discuss. Feel free to just put it in the chat and I will address it. But first, a couple of pieces of contact information. If you want to speak with an employment lawyer at our office, if you have questions about what to do and you need a starting point, our website, employmentlawyer.ca, is the place to go, is the place to start your search. We've got a ton of resources on the website, articles, blog posts, video clips, audio clips, you name it. If, again, it's an employment law issue, you will find it on our website. You can also email us. Send us a brief email. Give us a description of your problem. help@employmentlawyer.ca is the email address. Again, send us a brief email. I promise you someone will get back to you. Someone will answer those emails and put you in touch with one of our employment lawyers. You can, of course, also call us toll free. Feel free to reach out to our office anytime. Leave us a message. We have an intake team that is always standing by to answer calls and call people back. But if you don't want to contact us necessarily there, if you're viewing us right now, again, now is your opportunity to ask those employment law questions. Once again, my name is Alex Lucifero. I'm an employment lawyer, partner with Samfiru Tumarkin, LLP. Let us get started with the questions. I have Raj that came in first for the day at 2:01. Great timing, Raj, with your question. So let's tackle that. It's also a topic I think that I wanted to discuss right off the bat anyways. So we're going to kill two birds with one stone, as they say. So Raj asks, I'm on unpaid leave due to company vaccine policy. Hot topic of the day, these vaccination policies. Working from home since March 2020, can I apply for EI while on unpaid leave? I will be terminated on May 1st if not vaccinated by them. Raj, excellent question. As I mentioned, it's a hot button topic. Listen, I think the vast majority of individuals are vaccinated out there, so it might apply to only a few individuals, but it has dominated the employment law world probably for the past 3 to 4 months. This issue of these vaccination policies that employers have rolled out, a lot of them are illogical or unreasonable for a lot of employees. And Raj, I think you might be one of them. You mentioned yourself that you've been working from home since the start of the pandemic. I think there is little value and little point in requiring an employee that is able to work from home to confirm that they're vaccinated or to require vaccination as a necessary term of employment when that employee can obviously very safely working from home, but also successfully do their job remotely. And so, Raj, I have to say, my personal opinion, I think that my legal opinion as well, is going to be that it doesn't make sense to put an employee such as yourself on an unpaid leave. Actually, to go one step further than that, Raj, you can treat the unpaid leave as a termination. It's what we call a constructive dismissal, or maybe what's more basically known as a breach of contract. your employer, for no valid reason, effectively, has sent you home without pay. That is a termination in deeds, in actions, rather than words. Of course, you haven't received a termination letter, but your employer has basically taken the action of terminating your employment by sending you home without pay. Again, it's called a constructive dismissal in employment law. So, Raj, if you were inclined to do so, and I may even recommend it, we'd obviously need to chat and get a little bit more in depth, but it may be wise to treat the unpaid leave as a constructive dismissal, agree to a severance package, and get you moving on with your employment. Obviously, if you're not going to be vaccinated, your employment is going to be coming to an end anyway, and it looks like it's going to happen on May 1st, according to the company. Now, to answer your specific question, applying for EI was the question. I suspect that Service Canada will initially deny your claim. Service Canada has clearly said, for the record, and this is now going back a couple of months, and I don't think this has changed at all, that if you have been laid off or terminated from your employment for not following a vaccination policy, you will not be eligible to receive EI. So, Raj, I think if you apply EI, and of course Service Canada will learn that you've been put on unpaid leave because of a vaccination policy, your claim will likely be denied. Now, I don't agree with that position, quite frankly. I think that's an incorrect position from Service Canada's point of view. Again, especially, Raj, in a situation where you are able to work from home. So you can appeal that decision for Service Canada. As part of our severance negotiations, what we can also do is ask the company to provide you with a proper record of employment that then allows you to receive employment insurance along with your severance entitlements. So, Raj, you asked, you made some good points. You asked a valid question. If you haven't already, you need to have a conversation with one of our employment lawyers. You have options here, and you also likely have rights. And I think you have particularly strong rights because you are able to work from home. So, Raj, do reach out to us. Do give us a call. Send us an email. However you want to get a hold of us. There are various ways to do so. Let's have a chat about your situation, because it's not just about EI. It's about whether your employer can do this to you or not, and what severance you're owed if your employment has come to an end. Again, guys, as you just saw on the screen, the website, all of our contact information is there. Employmentlawyer.ca is where to go to find us. Help at employmentlawyer.ca is how to get a hold of us via email. You see it on the screen right there. Again, send us a brief description about your situation. If we've had a conversation here on this live stream, mention that you've already had a chat on the live stream, and then you want to speak with someone in more detail. And again, any employment law issue you have, please do not feel shy to reach out to us and to contact us. We have an intake team standing by to speak with you. The initial contact with our intake team is free, and a lot of times our consultations with our lawyers are also free. And so again, there should be no hesitation. It's a very casual conversation. There's no commitment. Do not be shy to speak to one of our employment lawyers. We do not bite. All right, guys, I see a few questions in addition to Raj's coming through, so let us get on board. I have heard if a company moves offices, extending your commute by a 30-minute drive, that can be treated as a dismissal. How does it work for those who are transit dependent? This is from JC 2004, who then follows up and says a short drive and equate to long transit times can equate. They certainly can, JC, especially at odd hours of the day and the route. That general premise is correct, JC, if there is a significant change in the location of your work. And again, the test is going to be, is it significant or is it substantial? Then an employee would be allowed to treat that change as a termination. Again, going back to Raj's initial question, it's what we call a constructive dismissal. What a constructive dismissal effectively is a significant change to the terms of your employment. And as I'm sure you can all imagine, there can be lots of different changes and significant changes to the terms of your employment. An employer can change your pay. They can change your work location, as JC presented. They could change your position. Any significant change to your position can be considered a constructive dismissal. Now, JC, to answer your question, I cannot tell you necessarily that extending a drive by 30 minutes, if that's kind of the precise calculation, is necessarily a constructive dismissal or not. It's going to be a question of what is reasonable and what were the existing terms of your employment. So, for example, if you're having to drive into work, let's say 45 minutes a day, and your employer changes location, moves offices or moves facility, and now your drive is, let's say, an hour and 15 minutes instead of 45 minutes, well, then that's a bit of a tighter margin. I mean, it still may be a constructive dismissal, but it's a bit of a more difficult claim. Certainly anything over and above 30 minutes, if we're in the 45-minute range, hour range, certainly, any kind of significant change to that effect is likely going to be considered a constructive dismissal. And yes, of course, JC, it matters what your current terms of employment are. And so if you are commuting by public transportation to work, and let's say it takes an hour by bus to get to work, and it's the case that now, because the company has changed offices, it's going to take you 2 hours to get to work, well, then yes, that is going to be a constructive dismissal. And because you require public transportation to get to work, it doesn't really matter what the difference would be by vehicle, by car, by driving in, because that's not your circumstance. Of course, somebody who did drive into work, well, then it would matter, what the distance is. It might also matter, are you going through a trafficked area? Do you have to, I don't know, drop your children off at daycare? And simply rerouting to a new location is going to double your travel time. The analysis is always very context specific. And so again, it requires tailored advice. And I see your follow-up, JC, and you heard from one of our other lawyers that 30 minutes might be a constructive dismissal. Listen, it may be, but I cannot tell you that is a blanket rule that applies to all individual employees. We need to know the specifics about your particular situation, how the change is affecting you and you specifically. And again, if is it a significant or substantial change, then you would have the right effectively to reject that change and claim constructive dismissal. In other words, claim severance. So, JC, don't rely on necessarily just this particular Facebook or YouTube stream for advice. If you're dealing with a situation yourself where your work is changing locations and that's going to affect you negatively, listen, you need tailored advice. You need to speak with one of our employment lawyers and make sure that you know exactly how strong your case is and also what your severance entitlements are. It actually might be a great opportunity to touch on the pocketemploymentlawyer.ca. That's a great resource that can do a couple of things for you. Number one, it can tell you whether you're dealing with a constructive dismissal or not. So just by answering a few questions on pocketemploymentlawyer.ca, you will get a sense of whether you're one of those individuals where you might be dealing with a constructive dismissal. The Pocket Employment Lawyer could also do something else, and it's something that our severance pay calculator does as well. It can tell you what kind of severance you would be looking at. For most employees out there, and I'm referring to non-unionized employees. For unionized employees, the analysis is very different. I should also, as a very quick aside, mention that most, if not all, of the advice I'm giving here, information I'm giving here, applies to non-unionized employees only. If you're dealing with a union, if you are a unionized employee, you will have to go to your union representative and to your collective agreement to have all of these questions answered. But listen, most of employees out there across Canada, and most certainly of our listeners and viewers, are going to be non-unionized employees. And so severance for non-unionized employees is based on their age, their position, and their years of service with the company. The older you are as an employee, the longer you've been with the same company, and the more specialized or the more senior your position is, the more severance you're going to get. It's not, I repeat, it's not going to be 1 or 2 weeks per year of service. You are likely looking at months as far as your severance entitlements. Severance could be for as much as 24 months, 2 years of pay for longer service and older employees. And so, again, if you've been let go or if you're dealing with a constructive dismissal, You need to know what your severance entitlements are. They're not going to be a mere 1 or 2 weeks of pay. They're probably going to be much more substantial than that. JC, I appreciate the question. Again, if you're dealing with a situation where your workplace is changing, or if any of you out there are dealing with a situation where your employer is asking you to change something, and if you feel as though the change is significant, again, it could be a change in pay structure, it could be a change to your position, your job duties, or your responsibilities, before you say yes, or before you say no for that matter, make sure you speak with an employment lawyer. An employer is not allowed to make big changes to the terms of your employment. You need to be willing to agree to that change. Of course, if it's a positive change, by all means, have at it. Go ahead. If it's a negative change, you have the right to say no. And if they try and force that change on you, you have the right to severance. All right. Next question, and keep them coming, guys. I appreciate all the questions. I want to answer as many as possible. We're about halfway through. For those just tuning in, my name is Alex Lucifero. I'm not some random guy. I am an employment lawyer, managing partner with Samfiru Tumarkin, LLP. We are taking any and all employment law questions. Throw the kitchen sink at me. If it's related to employment law, I promise I will answer it as best as possible. Employment law is my bread and butter. It's pretty much all I do. And so I don't know much about family law or about criminal law, but if you've got an employment law question, you're in the right place. All right. David asks, what if I worked for many years and they hired new workers, same less job title, and they get paid more? Is this legal? Good question, David, although I don't know if I necessarily have a great answer for you. And this, again, is assuming you're a non-unionized employee. If you're in a union, your pay is going to be structured. It's going to be based on your seniority and your position, and it'll be very, very detailed compared to other employees. In the non-unionized sector, David, if we're not talking about pay equity in terms of the difference between the pay between men and women, and there is legislation when it comes to pay equity there, and certainly men or women doing the same job should be paid the equal amount. Now, having said that, David, if an employer is hiring new employees and they are paying those new employees more than what you are earning for potentially doing the same job, listen, don't get me wrong. I don't agree with that. It's not necessarily illegal. And your terms of employment with your employer are not impacted by an employer's terms with another employee. And so, listen, I would have a conversation with my employer about that. And I think there's an obvious feeling of unfairness there if you are doing the same work as others but being paid less. I definitely get that. Can I tell you, David, that that is a constructive dismissal or that you can pursue an employer for severance for that reason? No, not necessarily. You may want to speak with the Ministry of Labor, for example, in Ontario, with respect to an issue like this. They might investigate an issue like that. And so you may have options, but it is not a perfect solution, and it's not as easy as what's good for the goose is also good for the gander. An employer has the right to contract separately with separate employees with respect to pay. And that, that makes for tough situations sometimes. Again, David, I'd encourage you, if the matter is a little bit more nuanced than that, if it is potentially a pay equity issue, if there's other stuff going on with respect to your employer, in addition to what they're paying you in this unfairness, listen, you need to have a chat, right? And certainly before you approach your employer, it might be wise to speak with one of our employment lawyers, develop a strategy. It's a lot of what we do as well. A lot of times we speak to employees who have already been let go for one reason or another. And, a big chunk of our job is negotiating proper severance packages, making sure that employees get what they are owed when they are let go. Another big part of our job is, again, speaking with employees who haven't been let go yet, who maybe are concerned about one issue or another. And we can certainly assist employees in strategizing how they should be speaking with their employers, what positions they should be taking, how they should be responding to what their employer is saying. That is very, very valuable advice. I can tell you that of the employees that I speak with, really almost always at the end of the conversation, the employee feels better. They feel like they have a plan, like they understand the way the law works. And certainly that is valuable advice. That peace of mind is worthwhile. All right. Keeping on with the questions here, a question from Sun, I believe. With mandates now being lifted, what are the options to challenge an employer's policy for mandatory vaccination or proof of negative tests every 72 hours? It's an interesting point, Sun, and certainly our position has been, our legal position has been, that since the rise of the Omicron variant, and I guess December 2021, January 2022, we've obviously seen that the game has changed effectively with respect to COVID. It's now clear that those that have been vaccinated are also able to transmit COVID. And so the logic behind, the rationale behind all of these mandatory vaccination policies has effectively eroded. I think when employers introduced these vaccination policies back in, let's say, the summer or the spring, or not the spring, but rather the fall of last year of 2021, I think the implication, or at least the assumption, was that, well, if we had a group of vaccinated employees and they were all vaccinated, they would all be immune from COVID and they wouldn't be able to transmit it. And we'd be creating these little safe bubbles of vaccinated employees. I think we now clearly know that that's no longer the case, that you can still contract and transmit COVID having been vaccinated. And so again, I think the rationale, the health and safety rationale behind these policies is somewhat eroded. Now, Sun, I need to say that despite what I feel is a kind of very rational, reasonable, scientifically based position with respect to these vaccination policies, what we have seen is that employers are not changing their policies. They're still moving forward and requiring all employees to be vaccinated, or those employees that are not vaccinated are being put on unpaid leave, or they're being terminated. And the reality is, Son, that we cannot force an employer to change their opinion in that respect. We cannot physically stop an employer from enforcing these policies. If you decide to remain unvaccinated, for example, or refuse testing if you've already agreed to that, it could be the case that your employment is going to come to an end over this issue. And so you have to decide, are you willing to lose your job over these vaccination policies? I can tell you that because of the point that you made and the point that I'm agreeing with, that actually, the foundation of these policies is eroding as we speak, I can tell you that you are going to be owed severance if you are let go as a result of a vaccination policy. But that still doesn't necessarily solve the problem of you losing your job as a result. And so that is a decision that employees have to make. Are you willing to lose your job over this issue? If you are willing to use your job, again, if you're a non-unionized employee, particularly if you're able to work from home, but even if not, and you've been let go because of a vaccination policy, you are likely, if not almost certainly, going to be owed severance. And so you should be reaching out to us for that reason. All right. Hopefully that helps, Sun, kind of point you in the right direction. Raj, as a follow-up, asks, he's next in line, have you had any success in fighting vaccine mandate terminations for non-unionized employees, especially those working from home? Well, Raj, if by success you mean, have we been able to obtain severance for those employees? Yes, absolutely. I've negotiated personally a good number of reasonable severance packages, proper severance packages for employees that were initially put on unpaid leave or terminated as a result of a vaccination policy. And that is a success because ultimately that is what an employee gets out of a situation like this. And that is the extent, most likely, of their severance entitlements. I mean, there may be a human rights issue here or there, but for the most part, employees are going to be owed severance when it comes to these kinds of terminations and unpaid leaves as a result of termination. All right, Body Sculpt by Jay asks, does the infectious disease, I assume, Jay, you mean the infectious disease emergency leave in Ontario, does it include unionized employees? Yes, it does. It applies to all employees, whether unionized or not. And I'll make a point, Jay, with respect to infectious disease emergency leave in a sec. But yes, that is a regulation that's found under the Employment Standards Act in Ontario. For all our non-Ontario listeners, this might be less relevant, but very quickly, Infectious disease emergency leave is effectively a COVID layoff. So it's when an employer lays an employee off temporarily because of COVID. Do not assume, for all of you in Ontario that are having to deal with infectious disease emergency leave, do not assume that an employer is allowed to put you on that kind of leave or that kind of layoff. You need to agree to a temporary layoff as an employee in order for it to be legal and enforceable. And actually, as an employee, in most cases, you have the right to refuse to be temporarily laid off, even if it's IDEL, infectious disease emergency leave, and treat it as a layoff. So for all of our viewers out there, if you have been temporarily laid off and your employer is now calling it infectious disease emergency leave, don't assume that what your employer is doing is correct. Speak with one of our employment lawyers. We need to investigate the situation. I bet you that 9 out of 10 times, that infectious disease emergency leave will be an illegal temporary layoff that you can treat as a termination, get your severance entitlements, and get moving on with your life. All right. Next question here. Jackson says, hello and thanks for the stream. My pleasure, Jackson. Thanks for tuning in. Marilena asks, on unpaid leave, work for a childcare center, and I'm told that I cannot get severance. My deadline is February 14th. If I'm terminated, is there anything I could do, especially if mandate dropped? Marilena, told that you can't get severance. I'm wondering, by whom have you been told that you cannot get severance? Have you received legal advice yet? And listen, it depends on your particular situation. Certainly, you need to get employment law advice. Certainly, if your deadline is February 14th, you need to decide, again, going to my initial point, are you willing to lose your job over this issue? If there is absolutely no way that you are going to be vaccinated, you have to be prepared for the fact that come February 14th, if that's the deadline, your employment is going to come to an end. It then becomes a question of, are you owed severance or not? And again, I'd be curious to know the details of your situation. Listen, there could be cases where an employee might not be owed severance because of a vaccination policy. One of those cases is where there is a government mandate in place. There aren't many very kind of industries. There aren't many industries, that have these kinds of mandates in place. In Ontario, at least, the only one is long-term care homes. I think there might be a couple of others in British Columbia, for example. But in Ontario, if there's a government mandate in place, if you work for a long-term care home and you're not vaccinated, that's a problem. You might not be owed severance if you're let go. The other situation might be if there's a third-party mandate involved. So, for example, Marilena, if you are working for a company and it is another entity that requires all employees of that company to be vaccinated, and it's really not your employer's fault that employees have to be vaccinated, it's this third party that requires it. Well, that's a difficult situation because, again, it's not necessarily your employer's fault that they can't continue your employment. It's what we call a frustration of contract situation. And that might be a situation where you are not owed severance. It might be a bitter pill to swallow, but it could be that you fall under one of those situations. If you don't fall in either one of those situations, again, a third-party situation or a government mandate, then you most likely would be owed severance. So we'd obviously need to discuss in more detail and figure out what's what with respect to your situation. I see a couple of other questions. We're going to do a rapid fire 2 minutes, guys. So hang in there if I haven't gotten to your question. Very quickly, Randolph, can my employer impose a vaccination policy on staff who are off on medical leave or disability leave? Randolph, to my previous point, they can. Doesn't make it right, but they can. You cannot physically stop an employer from doing that. The question is, are there any obligations on the part of the employer or rights on the part of the employee that flow from that? And the main one would be severance. It might also be a human rights issue. So you can't necessarily stop your employer from doing that, but there might be some consequences to an employer doing so. Cindy asks, if mandates are lifted, can employees who lost their jobs due to non-compliance get their jobs back? Most likely not, Cindy. Once you've been let go, the only recourse is severance. Your employer doesn't have to hire you back, but you would be owed severance in a situation if you've been let go. Cecilia asks, I love the rapid fire, guys. Keep them coming. If you ask questions, I will Answer. Where are we? Cecilia asks, when severance should be paid once the employment has been terminated. I'm not sure I understand the question, Cecilia. If it's when severance should be paid, well, if there's an agreement in place, if you've agreed on a severance package, the timeline is typically either on the company's next payroll date or the following payroll date. So it could be anywhere between 2 and 3 weeks is typical. Helen asks, do your lawyers mainly work independently or work together? It's challenging to be against a big company when many have a strong team of lawyers. Helen, occasionally we'll work together and occasionally we'll work independently. It's really a kind of a tailored approach of what's best for you in your case. I can guarantee you that a company can have a team of 30 lawyers. The law is still the law. It doesn't matter. If you have a claim to severance, if you have a claim to a certain right as an employee who's been let go or an employee who's in the workplace, quite frankly, I can care less how many lawyers they have. What's right is right and what's fair is fair. We'll have to leave it there, guys. My apologies. As you can see on the screen, we have another live stream coming up tomorrow with my friend and colleague Samara Belitsky at 1:30 Eastern Standard Time. You can certainly ask your question there. Samara is more than capable and more than happy to answer them. I wish you all the best. Thank you so much for tuning in. We will be back with our regular schedule of live streams throughout the week, including, as I mentioned, tomorrow. Until then, I wish you all the very best and do have yourselves a good rest of the day and a good week. Take care, everyone.